CH. Judiciary. Judiciary helps to enforce rule of law by the mechanism of courts. The Indian judiciary comprises of Supreme Court of India and High Court of different Indian states. We have an integrated judicial setup in our country which places Supreme Court at the top. Under a high court and below the state level, there is a hierarchy of subordinate courts. Articles 124 to 147 in Part 5 of the Constitution deal with the organization, independence, jurisdiction, powers and procedures of the Supreme Court. Supreme Court of India. The Supreme Court is at the peak of the Indian judicial system. It has the power to supervise and control the working of the entire judicial system in India. It ensures justice to all. It is one of the most important organs of the government established by the Constitution. It also preserves the T-balance between union and states by protecting rights of the center as well as states. It also serves as a guardian of Constitution and the fundamental rights. It determines the validity of the actions of different governmental organs and authorities through the process of judicial review. It not only interprets the Constitution, but sees to it, in discharge of its duties, that social, economical and political tendencies of the time are not ignored. It is a great organ of the system which has to draw the line between individual liberty and social control. Chapter 4 of Part 5, Article 124 to 147, provides for the Union Judiciary in detail. Organization of Supreme Court. Article 124 of the Indian Constitution provides that the Supreme Court of India shall consist of Chief Justice and not more than 7 other judges, until Parliament by law increases this number. The number has been increased by the Parliament from time to time. In 2009, the total number of judges was raised to 30 in addition to the Chief Justice from earlier number of 26. The Constitution, Article 145, provides that minimum of 5 judges are required to make any decision wherein any case of substantial question of law as to the interpretation of the Constitution is involved, constitutional bench judgments. Appointment of judges. 2. Billaboo. As per Article 124, 2. The judges of the Supreme Court are appointed by the President of India by warrant issued under his hand and seal after consulting such other judges of Supreme Court and High Courts as he may think necessary for such purpose. In all cases, the Chief Justice of India, CJI,
So, police or then police, and then first name police. So, third degree.
102. General Studies, Mains, Paper 2. Is consulted. As our President works under parliamentary system of the government, he also consults Council of Ministers in the appointment of the judges of the Supreme Court also. A convention was established that the senior-most judge of the Supreme Court be appointed as Chief Justice of India. Under the present system of appointment, the word consultations with judges is interpreted as concurrence. It means that President has to comply with the names recommended by a collegium of judges. Collegium refers to the group of 4 senior-most judges of the Supreme Court. Qualification of judges. According to the Constitution, a person is eligible for appointment as judge of the Supreme Court only if he is a citizen of India. Black circle, he has been a judge of a high court or of 2 or more such courts in succession for a minimum period of 5 years. or he has been an advocate for 10 years in a high court or high courts, or he is in the opinion of the president, a distinguished jurist. Term and removal of judges. The judges of Supreme Court hold office until they attain the age of 65 years. However, a judge can resign from his office earlier by writing under his hand to the president. The president can also issue order for the removal of a judge if an address has been presented to him in the same session for the removal of a judge on the ground of proved misbehavior or incapacity by the two houses of Parliament. Such a resolution must be supported by a majority of a total membership of the House, which should also constitute 2/3 road majority of the members present and voting in the House. The Judges' Inquiry Act, 1968, regulates the procedure relating to the removal of a judge of the court by the process of impeachment. Oath or affirmation of judges. A person appointed as a judge of the Supreme Court, before entering upon his office, has to make and subscribe an oath or affirmation before the president or some person appointed by him for this purpose. In his oath, he swears to bear true faith and allegiance to the Constitution of India, to uphold the sovereignty and integrity of India and to uphold the Constitution and the laws. Salaries and allowances of judges. The salaries, allowances, privileges, leave and pension of the judges of the Supreme Court are determined from time to time by Parliament. They cannot be varied to their disadvantages after their appointment except during a financial emergency. In 2009, the salary of the Chief Justice was increased from $33,000 to $90,000 per month. They are also paid sumptuary allowance and provided with free accommodation and other facilities like medical, car, telephone, etc. The retired Chief Justice and judges are entitled to 50% of their last drawn salary as monthly pension. Seat of Court of Judges. The Supreme Court has its permanent seat at Delhi. However, the court can have benches at other places as decided by the Chief Justice of India in consultation with the President of India. Independence of judiciary. Safeguards to ensure independence of judiciary are as follows. Separation of judiciary from the executive and legislature. Judiciary in India is neither a branch of the executive nor a handmaid of the legislature. It has an independent identity under the Constitution. It enjoys full autonomy in its working. Appointment of judges by the President. The method of appointment of judges has been very efficient. The judges of the Supreme Court and High Courts are appointed by the President. While appointing other judges the Supreme Court, the President consults the Chief Justice of India. In case of the appointment of the Chief Justice, the practice of appointing the senior-most judges to this high office is followed. In the case of subordinate courts, the judges are recruited through competitive examinations. Long-tenure judges of Supreme Court remain in office till they attain the age of 65 years. This age limit ensures a long tenure for the judges. J. T. Co. Was. With. It. Yes.
ప్లీజ్ కొంచెం పద్ధతిగా మన బాడీని చూసుకోవాలి మనం. నువ్వేంటి చైర్ లో కూర్చున్నావు? మనందరిలో గ్రేట్ ఎవర్రా? ఎవరు? నేనే. నేను రక్తం సరఫరా చేసి వీళ్ళంతా వెళ్తారు. సో నేను గ్రేట్ కాబట్టి నేను చైర్ లో కూర్చుంటా.
Constitutional Framework 103. Security of service. The judges in India enjoy good security of service. No judge can be removed from the office except by process of impeachment. Expenses charged on consolidated fund. The salaries, allowances and pensions of the judges and the staff as well as all the administrative expenses of the Supreme Court are charged on consolidated fund of India. Thus, they are non-votable by the Parliament. Freedom in appointing its staff. The Chief Justice of India can appoint officers and servants of the court without any interference from the executive. He can also prescribe their conditions of service. Prohibition of practice after retirement. A judge of the Supreme Court is prohibited to presence before any court or authority in India. Power to punish. The contempt of court. Courts in India have been given the power to punish all cases involving a contempt of court. The Supreme Court can punish any institution or matters referred to the Finance Commission. Person who is found guilty of contempt of court. Other similar instrument. Vast jurisdiction and the power of judicial review. Judiciary in India enjoys a vast jurisdiction. It acts as the guardian and interpreter of the Constitution, the protector of fundamental rights of the people and the mediator of disputes between the Union and the states. It has the power to determine the constitutional validity of every law. It can reject any law in case it is found to be against the Constitution of India. Indian judiciary is in no way subordinate to the other two organs of the government. Its decisions bind all. Such a powerful position helps the judiciary to maintain its independence. Thus, the Constitution of India incorporates all such features as are considered essential for the preservation of independence of judiciary. Jurisdiction of Supreme Court. The Supreme Court is the highest court in the country and therefore it performs important functions. The Constitution bestows both original and appellate jurisdiction upon the Supreme Court. It also performs some advisory functions. The main jurisdiction and powers of the Supreme Court are given as under. Original jurisdiction. India has a federal polity. The Constitution distributes powers between the national and state governments. There is every possibility of arising of dispute between the Government of India and one or more states. The Government of India and one or more states on the one side and one or more states on the other sides. Two or more states. In the above federal disputes, the Supreme Court has exclusive original jurisdiction. Exclusive means, no other court can decide such disputes, and original means, the power to hear such disputes in the first instance, not by way of appeal. This jurisdiction of the Supreme Court does not extend to the following: a dispute arising out of any pre-constitution treaty, agreement, covenant, engagement, synod, or interstate water disputes. A dispute arising out of any treaty, agreement, etc., which specifically provides that the said jurisdiction does not extend to such a dispute. Adjustment of certain expenses and pensions between the center and the states. Ordinary dispute of commercial nature between the center and the states. Resolving disputes requires legal interpretation of any provision of the Constitution. If legal interpretation is not involved, a suit cannot be brought before the Supreme Court. In 1977, the Union Home Minister Chaudhry Charan Singh told the chief ministers of 9 states ruled by the Congress to dissolve their assemblies to seek fresh mandate. One chief minister referred the case to the Supreme Court. It rejected the application on the ground that this is a political question and not legal. Center-imposed president's rule and assemblies were dissolved. Congress did the same thing with Janata Party ruled states when it came to power. Appellate jurisdiction. The Supreme Court is the final appellate court in India. The Supreme Court receives appeals from the high courts and other tribunals in the state in constitutional, civil, and criminal cases.
ఎప్పుడు పోదాము శ్రీకాకుళం काल असते సోమవారం అయితే ఆడ బాగా కుదురుతుంది అంటున్నావు పోతే సోమవారం పోయేటట్టు ప్లాన్ చేసుకోవాలి
104. Constitutional Cases Article 132(1) of the Indian Constitution reads that an appeal shall lie to the Supreme Court from any judgment, decree or final order of the High Court in the territory of India, whether in a civil, criminal or other proceeding if the High Court satisfies that the case involves the substantial question of law as to the interpretation of the Constitution. Even if the High Court refuses to give a certificate, Supreme Court may grant special leave to appeal if the court is satisfied that my particular case substantial question of law for interpretation is involved. Thus, the Supreme Court is the final court of interpretation and hence guardian of the Constitution. Civil Cases Constitution authorized people to appeal to the Supreme Court in civil proceedings. In civil cases, an appeal is to the Supreme Court from any judgment of a court if High Court certifies that the case involves a substantial question of law of general importance and that the question needs to be decided by the Supreme Court. Criminal cases an appeal may be made at the Supreme Court from High Court if High Court set aside an appeal and order of not guilty of crime passed by the lower court and sentenced the accused person to death. High Court has withdrawn from trial before itself a case from subordinate court and, in such trial, convicted the accused and sentenced him to death. High Court satisfies that the case is a fit one for appeal to the Supreme Court, but it is expected that as long as Parliament does not legislate, state High Court shall restrict to the cases mentioned above and shall normally be the final court of appeal in criminal matters. Hence, appeals will certainly be made to the Supreme Court where grave injustice is suspected. The Constitutional Article 134(2) authorizes the Parliament by the law to enlarge the appellate jurisdiction of Supreme Court in criminal matters. General Studies, Mains, Paper 2. Special Appeal of Supreme Court. Article 136 of the Constitution provides that the Supreme Court may, in its discretion, grant special leave to appeal from any judgment, decree, determination, sentence or order in any cause or matter passed or made by any court or tribunal other than court-martial ordinarily. Constitution lay down certain conditions under which appeal may be made to the Supreme Court, but Article 136 gives a clear power to listen to appeal notwithstanding any of the conditions. This has made Supreme Court very powerful. This power of Supreme Court is not subject to any constitutional limitations. Although the court's intervention under this jurisdiction is often sought, the court has not used this power frequently. The court has held in one of its cases that it is not possible to define with any precision the limitations on the exercise of the discretionary jurisdiction vested in Supreme Court by the constitutional provision made in Article 136. The limitations, whatever they may be, are implicit in the nature of character of the power itself. It being an exceptional and overriding power, naturally it has to be exercised with caution and only in special exceptional situations. Advisory jurisdiction. The Constitution says that the President of India may refer any question of law or fact of public importance to the Supreme Court for its advice, before he gives assent. In this matter, the Supreme Court may give or refuse to give its advice to the President. The President may refer such question not only where it has actually arisen, but also where it appears to the President that is likely to arise. The bench consisting of 5 judges sits and discusses the matter in detail and finds out whether the proposal is within the spirit of the Constitution. The opinion of the court is pronounced in open court. The opinion of the court is sent to the president. The president may or may not accept the opinion of the court. The judges are allowed to decide themselves and give the opinion jointly or separately concerning or dissenting. There are some provisions in which Supreme Court is bound to give the advice to the president. These are the disputes arising out of any treaty, agreement, etc. which has been entered into or executed before the commencement of the Constitution. A. B. Constitutional Framework 105. Powers of the Supreme Court. The Supreme Court has power of judicial review powers to act as a guardian of the Constitution and act as court of record. These are discussed as under. The Supreme Court is the guardian of our Constitution. The court does not allow any action of the executive or the legislature to violate any provision of the Constitution. The Supreme Court alone has the authority to explain the meaning of the Constitution. The Supreme Court may be called upon to decide when either the Union or the state governments have taken more power than they should, according to the Constitution. Judicial Review. Supreme Court is the guardian of the fundamental rights. It reviews any action of the government which violates any provision of the fundamental rights. This power to review the action of the government is called judicial review. Judicial review is the most important part of the Indian Constitution. Expressing the importance of this power of Supreme Court, our founding fathers described the court as the guardian of the Constitution, or a champion of liberties, or a watchdog of democracy. A court of record. According to Article 129, the Supreme Court is a court of record. The two chief characteristics of a court of record are: 6. The proceedings of the court of record, preserved, are called records and are conclusive evidence of that which is recorded by it. 1. Once a court is made a court of record by statute, its power to punish for contempt necessarily allows from that position. In one of its judgments, the Supreme Court said that this is the whole point of court of record. All its judgments are preserved, and not merely those which are specially approved or favored. Because they operate as precedents and may be studied and followed as occasion requires. 3 judges' cases and debate over collegium system. S.P. Gupta versus Union of India case, 1981, first judge's case. In this case, court opined that advice tendered by Chief Justice of India, CJI, is nothing but exchange of views. It does not have legal function and cannot be considered as binding on President of India. In this way, Supreme Court itself has accepted the supremacy of executive in the matters of judicial appointment. Advocates on Record Association case, 1993. Second judge's case. Nature of consultation and overruled its her decision to specify that advice is of the nature of. In this case, again, Supreme Court interpreted the concurrence, and binding court further said that since judicial powers cannot be shared with and judicial function cannot be transferred to any other organ of the government, the recommendation tendered by CJI shall be binding on President. However, it is required for the CJI to take the opinion of 2 senior-most judges of Supreme Court. Court also specified that the process of appointment of Supreme Court level can be initiated only by CJI, and in the case of any event of conflict between the constitutional authorities, always the opinion tendered by CJI shall prevail. Re-Presidential Reference Case, 1998. Third Judge's Case. In this case, court again considered the nature of consultation under 124(2) and opined that sole opinion of CJI cannot be considered as an opinion of judiciary as a board. A new corpus or collegium comprising senior-most judges of SC and CJI shall be constituted, which shall tender their advice to the executive. If any of the two judges are giving adverse opinion, then such advice shall not be referred to President of India. In regard to the appointment of High Court judges, collegium shall comprise two senior-most judges and CJI, and in the matter of transfer apart from 4+1 collegium, 2 persons la. Chief Justice of a High Court from where transfer is taking place and Chief Justice of a High Court receiving the person shall be the member of collegium.
Advert.
106. General Studies, Mains, Paper I. Arguments against the collegium system. The arguments against the collegium system or the system is not transparent at all. A few of the top judges got together and they decide who to make a judge. It is not as if everybody gets a chance to apply to be a judge. These are matters of public employment. In all other matters of public employment, everybody gets a chance to apply. Here, there is no such thing. Nobody knows how people are selected and what deliberations go on. This is not the scheme of the Constitution. Collegium system has been evolved by virtue of judicial interpretation. The present system has the administrative burden of appointing and mansering judges without a separate secretaire or intelligence-gathering mechanism dedicated to collection and checking personal and professional backgrounds of prospective appointees. The Constitution Bill, 2014. The Constitution, 121st Amendment, Bill, 2014 sought to amend the provisions of the Constitution related to the appointment of Supreme Court and High Court judges and the transfer of High Court judges. According to the Statement of Objects and Reason of the bill, there is a need for a broad-based National Judicial Appointment Commission, NAC, for making recommendations for selection of judges. The bill sought to enable equal participation of judiciary and executive, ensure that the appointments to the higher judiciary are more participatory, transparent, and objective. National Judicial Appointment Commission, NJAC. Article 124(2) of the Constitution provides that the President will make appointments of Supreme Court, SC, and High Court, HC, judges after consultation with the Chief Justice of India and other SC and HC judges as he considers necessary. The bill sought to amend Article 124(2) of the Constitution to provide for a commission, to be known as the National Judicial Appointments Commission, NJAC. The NJAC would then make recommendations to the President for appointments of SC and HC judges. Comparison of the NJAC. A new article. Article 124A provided for the composition of the NJAC. The NJAC would consist of Black Circle Chief Justice of India, Chairperson. 2 senior-most Supreme Court judges, the Union Minister of Law and Justice. 2 eminent persons, to be nominated by a committee consisting of the Chief Justice of India, Prime Minister of India and the Leader of Opposition in the Lok Sabha. Of the 2 eminent persons, 1 person would be from the SC, Street, OBC, minority communities or be a woman. The eminent persons shall be nominated for a period of 3 years and shall not be eligible for renomination. Functions of the NJAC. A new article, Article 1248, provided for the following functions of the NJAC. Recommending persons for appointment as Chief Justice of India, Judges of the Supreme Court, Chief Justices of High Courts and other Judges of the High Courts. Recommending transfer of Chief Justices and other Judges of High Courts from one High Court to any other High Court. Ensuring that the persons recommended are of ability and integrity. The NJAC shall not recommend a person for appointment if any two of its members do not agree to such recommendation. Power of Parliament to make law on procedures. A new article, Article 124C, sought to enable Parliament to pass a law to Black Circle regulate the procedure of appointments. Black Circle empowered the NJAC to lay down the procedure for its functioning and manner of selection of persons for appointment through regulations. Constitutional Framework. 107. Power of the President to require reconsideration. The President may require the NJAC to reconsider the recommendations made by it. If the NJAC makes a unanimous recommendation after such reconsideration, the President shall make the appointment accordingly. Limitations of NJAC. The attempt to formulate NJAC has been noble and a genuine way forward to work for a separation of powers between different organs of the government. However, the move has irritated the judiciary. A more benign approach would have been to take all the stakeholders in confidence, including judiciary, and the provisions of the bill would have been formulated by consensus. Some other limitations can be listed as follows. There is no say of state-level institution even while appointing high court judges. There is no equality of opportunities. Only certain people already in the judiciary or having close nexus with the political masters have opportunities. Normal public may not even apply for the post of judges. NJAC does not even address the issue of gender equality and appointment of vulnerable sections in appointment. NJAC is only a statutory act and is vulnerable to be frequently amended, if it does not suit the executive of the day. Views of the Supreme Court on NJAC. It said that, it is difficult to hold that the wisdom of appointment of judges can be shared with the political executive. It is said that, in India the organic development of civil society has not as yet sufficiently evolved. The expectation from the judiciary to safeguard the rights of the citizens of this country can only be ensured by keeping it absolutely insulated and independent from other organs of governance. Present status of NJAC. The NJAC Act, 2014 was passed by the Parliament of India, and this constitutional amendment bill was also ratified by the 16 of the state legislatures of India. It was subsequently assented to by the President of India on the 31st of December 2014. However, on the 16th of October 2015, the Constitution Bench of the Supreme Court struck the NJAC Act as unconstitutional by 4-1 majority. It upheld the collegium system for appointment and transfer of judges in the higher judiciary. High Court. The High Courts stand at the apex of the state's judicial administration, even though they form a part of the single integrated judicial system headed by the Supreme Court of India. Under the Constitution, every state has a high court, which operates within the territorial jurisdiction of the state. However, the parliament can set up common high court for 2 or more states, e.g., there is a common high court for the states of Punjab, Haryana and the Union Territory of Chandigarh.
సార్ నమస్కారం సార్ మల్లికార్జున్
Composition of High Court.
అది
Every high court consists of a chief justice and such other judges determined by the president may from time to time. Since the number of the judges of the high courts has not been fixed by the Constitution, there is variation in the strength of the various high courts. The Chief Justice of the High Court is appointed by the President under his hand and seal. However, the President makes the appointment of the Chief Justice of the High Court in consultation with the Chief Justice of India and the Governor of the concerned state. In the appointment of the other judges of the High Court, the President, in addition to the Chief Justice of India and the Governor of the state, also consults the Chief Justice of the concerned High Court. The President of India is authorized to appoint additional judges if there is temporary increase in the business of the High Court or the work of the High Court is pending. Such appointments can be made only from amongst persons who possess due qualifications, and their appointment cannot be for a period exceeding 2 years. In case of exigency, even the retired judges can be invited to participate in the proceedings of the court and are entitled to all facilities available to a high court judge. (108) General Studies, Mains, Paper I. Qualifications of Judges. A person to be eligible for appointment as judge of the state high court should have following qualifications. He must be citizen of India. He has been the advocate of a high court or of 2 or more such courts in succession for at least 10 years. He has held a judicial office in the territory of Vidya for at least 10 years. Earlier, even those persons could be appointed as judge of high courts who, in the opinion of the President of India, were distinguished jurists. However, this qualification has since been omitted from the Constitution by the 44th Amendment Act. Term and removal of judges. The term of office of the High Court judges is up to the age of 62 years. However, a judge can resign his office earlier by addressing his resignation to the President of India. He can also be removed from his office on grounds of proved misbehavior or incapacity. For this purpose, both the houses of the Parliament must pass a resolution for the removal of the judge of a high court by majority of total membership and 2/3 road majority of the members present and voting in each house, and request the President to remove such a judge. While such a resolution is under consideration of the Parliament, the concerned judge must be given a chance to defend himself. Salary and allowances of judges. It may be noted that the salary, allowances of judges and their knights with regard to leave of absence or pension cannot be varied to their disadvantage during their tenure. However, during the financial emergency, the President is empowered to reduce the salaries of the judges of the High Court. The salaries and allowances of the judges of the High Court and the other expenses in connection with the maintenance of the state High Court are charged on the consolidated fund of the state and are not subject to vote of the state legislature. However, the pensions of the High Court judges are charged on the consolidated fund of India. Oath of office and immunities of restrictions judges. Every person appointed as a judge of high court has to state or some person appointed by him. The judges of the state high courts are entitled to the same immunities which are enjoyed by the judges of the Supreme Court. Their conduct cannot be examined by the state legislature. Only the parliament can examine their conduct, and that too only when a motion for the removal of a judge of high court is under consideration. The judges of the high court are not permitted to practice before the state high court after their retirement. However, they are authorized to practice before the Supreme Court of India and other high courts, to fake oath or affirmation before the governor of the powers of the high courts. The Constitution does not make any detailed provision regarding the powers and jurisdiction of the high courts. Article 225 of the Constitution, which deals with the jurisdiction of the state high courts, clearly lays down that the powers of the high courts shall be same as they were immediately before the commencement of the Constitution. Thus, the high courts are the highest courts of appeal in both civil and criminal matters. Cases relating to admiralty, matrimonial matters, and issues concerning the contempt of the court can be taken directly to the high courts. Further, the restriction which operated with regard to certain high courts in cases pertaining to revenue collection has also been removed. Now, these cases fall within the original jurisdiction of the state high courts, and the courts have been given full powers to make laws to regulate the business before them. In addition, the Constitution has vested some other powers on the state high courts. Power of superintendence. Every high court has the power to superintend the working of the courts and tribunals throughout the territories in relation to which it exercises jurisdiction. For the discharge of this function, the high courts can call for reports from such courts, make and issue general rules and prescribe forms for regulating the practice and proceedings of such courts, and prescribe forms in which the books, entries and accounts shall be kept by the officers of any such courts. Constitutional framework. 109. The High Court can also settle tables of fees to be allowed to the sheriff, all clerks, officers of such courts, attorney, advocates and pleaders practicing therein. However, the High Court does not enjoy any power of superintendence over the courts or tribunal constituted by or under any law relating to the armed forces. The power of judicial superintendence granted to the state high courts also implies that they can take necessary steps to ensure that the lower courts discharge their duties in a legal manner. The high court can, therefore, transfer cases from one lower court to another lower court or dispose of the case itself. In this regard, Article 228 of the Constitution provides, if the High Court is satisfied that a case pending in a court subordinate to it involves a substantial question of law as to the interpretation of Constitution, the determination of which is necessary for the disposal of the case, it shall withdraw the case. It may either dispose of the case itself or determine the said question of law and return the case to the court from which the case has been so withdrawn, together with a copy of its judgment on such question, and the said court shall on receipt thereof proceed to dispose of the case in conformity with such judgment. The actual working of the High Court since the inauguration of the Constitution has amply demonstrated that they have given precedence to the writ petitions over other works and knocked down a number of statutes and executive orders on the ground that they encroached upon the citizens. The fundamental rights of court of record, Article 215 of the Constitution declares every high court as a court of record which has all the powers of such a court, including the power to punish for contempt of itself, power to regulate its working. The Chief Justice of the High Court is authorized by the Constitution to appoint officers and servants of the High Court. However, the governor of the state can require him to consult the State Public Service Commission in this connection. The conditions of service of the officers and the servants of the High Court are also laid down by the Chief Justice of the Court or some other judges or officers of the court authorized by the Chief Justice to make rules for the purpose. However, the rules relating to salaries, allowances, leave or pension require the formal approval of the governor of the state. Extension of its jurisdiction. The jurisdiction of the High Court can be further extended under a law of the Parliament. However, the state legislature does not enjoy any power to increase, restrict or abolish the jurisdiction of the High Court. The Parliament can restrict or curtail the powers of the state high courts. A survey of the powers and functions of the state high court shows that it is primarily a supervisory court which exercises supervision over the subordinate courts and tribunals within its jurisdiction. At the same time, it also acts as the guardian of the fundamental liberties of the people against possible encroachment by the legislature and the executive. Writ jurisdiction of Supreme Court and High Courts. The Supreme Court, under Article 32, and the High Courts, under Article 226, can issue writs. Further, the Parliament, under Article 32, can empower any other court to issue these writs. Since no such provision has been made so far, therefore, only the Supreme Court and the High Courts can issue the writs. These writs are borrowed from English law where they are known as prerogative writs. The writ jurisdiction of the Supreme Court differs from that of a High Court in three respects. These are as follows. 1. The Supreme Court can issue writs only for the enforcement of fundamental rights, whereas a High Court can issue writs not only for the enforcement of fundamental rights but also for any other purposes. The expression "for any other purpose" refers to the enforcement of an ordinary legal right. Thus, the writ jurisdiction of the Supreme Court, in this respect, is narrower than that of High Court. 2. The Supreme Court can issue writs against a person or government throughout the territory of India. A High Court can issue writs against a person or a
ఆదివారం దొరుకుతాయి ఇన్న చేసాపా కట్ చేసి ఇస్తారు మంచిది మనం పంప లేపుతాం తెలుసు కదా నాకు చేపలు అంటే భలే ఇష్టం ఏమి ఎందుకన్నట
110. General Studies, Mains, Paper I. Government or authority residing located within its territorial jurisdiction only or outside its territorial jurisdiction only if the cause of action arises within its territorial jurisdiction. 3. A remedy under Article 32 is in itself a fundamental right and hence, the Supreme Court may not refuse to exercise its writ jurisdiction. On the other hand, a remedy under Article 226 is discretionary and hence, a high court may refuse to exercise its writ jurisdiction. Article 32 does not merely confer power on the Supreme Court as Article 226 does on a high court to issue writs for the enforcement of fundamental rights or other rights as part of its general jurisdiction. The Supreme Court is thus constituted as a defender and guarantor of the fundamental rights. Types of writs issued by Supreme Court and High Courts. The types of writs issued by Supreme Court and High Courts are have corpus, mandamus, prohibition, certiorari, and quo warranto. These are discussed as under habeas corpus. It is an order issued by the court to a person who has detained another person to produce the detainee before it. The court then examines the cause and legality of detention. It would set the detained person free if the detention is found to be illegal. Thus, this writ is a defensive wall of individual liberty against arbitrary detention. This writ can be issued against both public authorities as well as private individuals. Mandamus. It is a command issued by the court to a public official taking him to perform his official duties that he has failed or refused to perform. It can also be issued against any public body, a corporation, an inferior court, a tribunal or government for the same purpose. Prohibition. It is issued by a higher court to lower court or tribunal to prevent it from exceeding its jurisdiction or illegally taking a jurisdiction that it does not possess. Thus, unlike mandamus that directs activity, the prohibition directs inactivity. This writ can be issued only against judicial and quasi-judicial authorities. It is not available against administrative authorities, legislative bodies, and private individuals or bodies. Certiorari. It is issued by a higher court to lower court or tribunal either to transfer a case pending with the latter to itself or to reject the order of the latter in a case. It is issued on the grounds of excessive jurisdiction or lack of jurisdiction of error of law. Thus, unlike prohibition, which is only preventive, certiorari is both preventive as well as curative. Till now, the writ of certiorari could be issued only against judicial and quasi-judicial authorities and not against administrative authorities. However, in 1991, the Supreme Court ruled that the certiorari can be issued even against administrative authorities affecting rights of individuals, like prohibition. Certiorari is also not available against legislative bodies and private individuals or bodies. Which warrant? It is issued by the court to inquire into the legality of claim of a person to a public office. Hence, it prevents illegal acquiring of public office by a person. This writ is issued only in case of a substantive public office of a permanent character created by a statute or by the Constitution. It cannot be issued in cases of ministerial office or private office. Unlike the four writs, this can be sought by any interested person and not necessarily by the aggrieved person. Public interest litigation, PIL. PIL means a legal action initiated in a court of law for the enforcement of public interest or general interest in which the public or class of the community have financial interest or other interests by which their legal rights are affected. Public interest litigation's explicit purpose is to deal with matters affecting larger public interests. Transparency in public life and fair judicial action are the right answers to check increasing menace of violation of legal rights. PIL had begun in India towards the end of 1970s. They delivered some landmark judgments which opened up new vistas in PIL. Constitutional Framework. 111. PIL is a process of obtaining justice for the people and of voicing people's grievances through the legal process. The aim of PIL is to give to the common people of the country access to the courts to obtain legal redress. The traditional rule of locus standi, that a person whose right is infringed alone can file a petition, has been considerably relaxed by the Supreme Court in its recent decisions. Now, the court permits public interest litigation at the instance of the so-called public-spirited citizens for the enforcement of constitutional and legal rights. Now, any public-spirited citizen can approach the court for the public cause in the interests of the public or public welfare. Developments in the field of PIL till 1960s and 1970s. The concept of litigation in India was still in its initial form and was seen as a private pursuit for the confirmation of private vested interests. Litigation in those days consisted mainly of some action initiated and continued by certain individuals, usually addressing their own grievances, problems. Thus, the initiation and continuance of litigation was the prerogative of the injured person or the aggrieved party. Even this was greatly limited by the resources available with those individuals. There were very little organized efforts or attempts to take up wider issues that affect classes of consumers or the general public at large. However, all these scenarios changed during 80s with the Supreme Court of India-led concept of public interest litigation, PIL. The Supreme Court of India gave all individuals in the country in the newly formed consumer groups or social action groups an easier access to the law and introduced in their work a broad public interest perspective. However, the development of PIL has also uncovered its pitfalls and drawbacks as the abuse of PIL is increasing along with its extended and multifaceted use. Of late, many of the PIL activists in the country have found the PIL as a handy tool of harassment since insignificant cases could be filed without investment of heavy court fees as required in private civil litigation. Just as a weapon meant for defense can be used equally effectively for offense, the lowering of the locus standi requirement has permitted privately motivated interests to pose as public interests. The abuse of PIL has become more rampant than its use, and genuine causes began to be viewed with the suspicion. Guidelines for the use of PIL. With the view to regulate the abuse of PIL, the Apex Court itself has framed certain guidelines. The court must be careful to see that the petitioner, who approaches it, is acting bona fide and not for the personal gain, private profit, or political or other oblique considerations. The court should not allow its process to be abused by politicians and others to delay legitimate administrative action or to gain political objectives. The Supreme Court laid down the following guidelines for checking the misuse of the PIL. 1. The court must encourage genuine and bona fide P, and effectively discourage and curb the PIL field for extraneous considerations. 2. Instead of every individual judge devising his own procedure for dealing with PIL, it would be appropriate for each high court to properly formulate rules for encouraging the genuine P filed and discouraging PIL field with oblique motives. 3. The court should prima facie verify the credentials of the petitioner before entertaining the PIL. 4. The court shall be prima facie satisfied regarding the correctness of the contents of petition before entertaining the PE. 5. The court should be fully satisfied that substantial public interest is involved before entertaining the petition. 6. The court should ensure that the petition which involves larger public interest, gravity, and urgency must be given priority over other petitions. 7. The court before entertaining the PIL must ensure that the PIL is aimed at redressal of genuine public harm and public injury. The court should also ensure that there is no personal gain, private motive or oblique motive behind filing pill.